Hey folks, James Abrenio coming to you from Abrenio Law, your Northern Virginia personal injury and criminal defense law firm. Um, Going forward, I'm going to start doing, and I'm going to start trying to do videos a little more regularly. If you're pay attention to my channel at all, you see in the past I do very uh, specific topic videos, and I think them out ahead of time. I write articles about them, and I kind of pre-plan them. But what I'm going to try to do going forward is do videos where I'm reacting to things as I'm seeing them live, maybe some current events, maybe some local legal issues or political issues when it comes to General Assembly. Also, sometimes I see things in court that I think are very instructive that don't necessarily deal with my own cases and usually won't because I don't want to really talk about my ongoing cases as they're happening without client consent, obviously. But what I do like to do oftentimes when I'm in court and I'm waiting for my cases to be called, I like to observe what's happening because I think learning from other people's experiences and sitting in court and watching judges is very instructive. You get a chance to learn what judges are thinking, how they rule, and once in a while you'll see a very unique legal issue that makes the wait of an hour or so worth the time because I, as a lawyer, can learn a lot by just watching court. And I've been practicing about 15 years now, and I still find watching court very useful, very informative. So when I'm in there, if I'm not actively litigating, I oftentimes will be watching just because it's useful. So today, as I'm waiting for an expungement hearing, I had an opportunity to watch a very interesting argument about a non-suit, and I did not understand. I did not get the details of the underlying lawsuit, but from what I could tell, it sounded like an individual representing themselves pro se in a personal injury case on a slip and fall. It sounds like they had sued for, I think, Home Depot. And I imagine, again, I didn't see the complaint itself, but from what I surmised from what was being discussed, they probably sued Home Depot for some type of defect that caused them to be injured. Um, but what made this hearing so interesting is the plaintiff there was asking for what we call a non-suit, a second non-suit. And I've actually done a video on what non-suits are under Virginia law, and it's a very unique and I think special aspect of Virginia personal injury law, particularly. But it deals with other civil cases, of course, as well. But if you want to look at the code itself, it's 8.01, Virginia Code 8.01-380. And so what made this motion unique by this pro se individual, this person representing themselves, is they'd actually asked for a second non-suit, not a first one. So under Virginia law, as I've written about and done videos about before, you're permitted to have one non-suit, assuming other conditions are met, as a matter of right. And that's essentially where you voluntarily drop the case, and then by Virginia law, you're then given an additional 6 months to refile it and then re-begin the case. So sometimes you'll file a non-suit because the case isn't right for whatever reason. Maybe a witness disappears, maybe your expert backs out on you. So Virginia law, having one non-suit by right is really useful because it allows you essentially a second bite at the apple if things fall apart at the last minute or other reasons as well. But again, this case was very unique because the individual was asking for a second non-suit. And it appears that at least what his argument was is because of COVID and him being in a difficult mental state and having lost a bunch of family members, it sounded like maybe due to COVID, he just wasn't in a position to prosecute his case. And so he had to file a second non-suit. He needed more time. And so what was fascinating is I guess the judge had entered a non-suit order, and then the defense argued that they should reopen that or make that decision, vacate that decision, and not grant the non-suit. And they made two arguments, which was very fascinating. If you look at the statute, they made an argument about lack of notice. They essentially said that they didn't have notice of the non-suit. That was their first argument. And then the second argument was, regardless, it was not good cause in order to grant the non-suit. So the section of 8.01 380-B, subsection B, was one that was really heavily litigated about the meaning behind of it. So when it comes to the first argument about lack of notice, subsection B, and I'm going to get a little technical here because it's very interesting. It says subsection B, only one suit non-suit may be taken as a cause of action or against the same party as to the proceeding as a matter of right. And again, that's the chance for the first non-suit. Although the court may allow additional non-suits upon reasonable notice to counsel of record for all defendants and upon a reasonable attempt to notify any party not represented by counsel. So in this argument, the defense was saying that the plaintiff, the injured party or the alleged injured party, didn't give them proper notice. Upon questioning by the court, the pro se individual said, look, I mailed the notice over to defense counsel, and defense counsel presumably said, look, I didn't receive it, so I didn't get notice. So a couple tips here when we're talking about a statute requiring notice to another party. I always tell people, particularly if it's a pleading and it sounds like it's an important pleading, send the document, whatever you're sending over, by certified mail or by email or whatever way you can verify that the other side got it, and you can confirm in court that you sent it. But also check with them. Hey, did you receive this document? It sounds like what this individual did was he mailed the notice a week before the hearing. The hearing came up, and the judge granted the order of non-suit, but it sounds like the defense never got the notice. So the judge ultimately said that the notice was not given. And I think that was the right call, because if the defendant doesn't actually have the document, it's not fair to them because they were never given an opportunity to defend themselves. So the judge ultimately said, look, that's not proper notice. How the plaintiff could have fixed that is, again, emailed it over, said, hey, I just want to confirm you've received this. And then once they get the response back, yeah, we got it, then that's confirmation there. Or email it over and then give a call and say, hey, look, I know you got it. Now, of course, there are other ways to do it: certified mail, hand delivered, those kinds of things as well. But I think once you confirm with the other side they've received it, it's kind of hard for them to say they didn't get notice, particularly in a case like, at least dealing with this statute. And I do want to qualify that with, there are other issues with notice that this may not be applicable. I'm talking about really this statute. What I would have done here is I would have made sure that I've got confirmation from the other side before the motion was had. Now, the second question was whether or not the plaintiff had good cause in order to deserve the non-suit, and did it prejudice the defendant. And what's interesting about here is the term good cause isn't anywhere in this statute. It says, let's see, again, although the court may allow additional non-suits upon a reasonable notice, and that's kind of the language they use now. It sounds like defense counsel did research, and there was cases that said that in order for this statute to apply for a second non-suit, you've got to show good cause, that term good cause. And she may very well be right. I haven't researched that issue. That being said, in my practical world about what I'm doing as a plaintiff's attorney, I know that, at least for me, it would be very difficult to get a second non-suit because I'm an attorney. I think a judge is going to hold me to a high standard. What this person did, this pro se person, was essentially establish why he needed a non-suit because of his life circumstances. I will say, and the defense argued against that and said, look, that's not good cause. He's had multiple years to pursue this. And I could easily see a different judge having ruled a different way and saying he didn't demonstrate good cause. So I, as a plaintiff's attorney, if I'm asking for a second non-suit, my point here is I better have a very, very good reason that I need that second non-suit, because I'm worried the judge would never grant that. So that's another point to be had. Under Virginia law, if you've got a Virginia accident case, either you're represented by counsel, you're representing yourself in court. First of all, I always recommend people need to get an attorney if you're going to go and litigate in court. I think it's reckless not to do that. But for the attorneys, you got to make sure to properly prosecute your case. If you file suit, Virginia gives you a year to serve that suit, but you don't want to wait on that. If you're going to file it, be ready to serve it unless there's a reason not to. And then get your trial date as soon as you can and prosecute the case. You don't want to be in a position where you're just kind of sitting on it and then last minute you need a non-suit, like say here a second time, and you're left without much luck. My thought is the reason he ultimately needed a second non-suit is because he hasn't done anything on the case. And look, I'm not trying to judge that person. Life circumstances happen, but you as an attorney, or if you're an injured party and you have an attorney, you should be working up the case and pursuing it the best you can. Now, I'm not saying you got to do everything, do this day 5, do this day 6. I understand every case is different, but properly prosecute your cases. And if you're represented by counsel, check in with the attorney. Hey, is this being properly prosecuted? You don't want to be in a position to where things are delayed just because things are being sat on and nothing's happening. So a very interesting hearing. I suggest any lawyers out there, especially you young people, to get into court. Even if you have a hearing, wait around so you can watch other things. Get there early so you can watch other hearings. Watch what judges are doing, because, again, that's going to be very instructive. Because before you know it, you're going to be appearing in front of that same judge, and having seen them decide things previously, you get a better understanding of how they think. So hopefully this is useful. Wish you guys the best. Have a great weekend. Happy Friday. Thanks. Bye.